Thank you, Elisa, for this. The floor is yours. Thank you. Thank you very much. I'm sorry I cannot speak French, so I will speak in English. I hope it's okay for you. My name is Roberto Pettinelli. I'm professor of Le Bourlot at the University of Montpellier. My contribution concerns the relationship between the religious freedom and employment in the public sector in Italy in light of the European legislation, and aims to answer to the following question. Is there a right to religious difference in the workplace for employees of public administrations? And when I say religious difference, I'm referring to displaying, for example, a religious symbol or adopting a particular style of dress, an hijab, for example, or praying in a public place, or other behavior prescribed by the religious professor. So, is there a right of this? And when considering this question, it is important to note that public employment differs from private employment, primarily in terms of the employer, the public administration, of course, and above all, the purpose of the work. That is, ensuring the proper functioning, impartiality, and efficiency of administrative action as prescribed by our Article 97 of the Italian Constitution. So these characteristics exacerbate the tension, if not the conflict, between the two dimensions of the religious freedom, the objective and subjective one. The objective dimension of religious freedom concerns the public employer. That is the public administration, which has a duty to adopt a neutral attitude, reflecting the principle of the non-confessional nature of the state, also a principle found in the Article 7 and 8 of the Italian Constitution, and on the other hand, to maintain cooperative relationships between the public authorities and the various religions. The non-confessional nature of the state does not consist in a policy of absence of communication or relationships with religious confessions, but rather in forms of cooperation inspired by equal treatment of the various religious groups, without any of them receiving favorable treatment. From this perspective, religious freedom cannot in any way be interpreted as the state denying the phenomenon of religious difference, and on the contrary, the state itself guarantees and protects religious freedom, and it is, in doing that, neutral. The subjective dimension of the religious freedom, on the other hand, manifests itself essentially on the part of the worker, because it concerns the external manifestation of a person's religious beliefs through expressions or behavior that reveal their religious beliefs or affiliations. This could include displaying, as I said, a religious symbol or adopting a particular style of dress and so on. So, what is the relationship between the neutrality of the state and the freedom of the individual workers that works for the state or for a public body, public administration? It is possible to consider, and if so, to what extent, that the neutrality of the state also extends to public employees? This is the core question. I believe that the answer to this question lies in the meaning attributed to the terms neutrality. As I said, the state needs to be neutral. And the term neutrality, not surprisingly, is interpreted differently by the member states of the European Union. For example, the French concept of the state secularism, an imperfect translation, as I learned from Daniele, of the term laïcité, is particularly strict and requires not only that public employees act impartially in their work, but also that they show no religious preference in their actions, as they are considered to personify a service that must appear as neutral. The boundaries of this policy of so-called, the term is important, exclusive neutrality have been defined both by case law and by specific interventions by the French legislator, including recent ones, as I had the opportunity to hear another last week, thanks to a lecture organized by Professor Mazzoli and Professor Ferrari in our university, and I thank them. I also discovered that in Germany, however, a different concept prevails, the concept of inclusive neutrality, or open neutrality, which strikes a better balance between conflicting interests. Starting from the position that the state should be ideologically and religiously neutral, which entails equidistance from all faiths, the German liberal democratic approach promotes pluralism and individual self-determination. So this allows public employees to express their religious affiliations, albeit with certain limitations. For instance, the German Constitutional Court ruled that a regional law restricting the use of symbols, religious symbols, of course, by teachers, was unconstitutional, precisely because of an open concept of neutrality. But, however, on the other hand, it upheld similar legislation for judicial trainees, as stronger requirements for state neutrality apply in the administration of the justice. In Belgium, and this is another case, the Constitutional Court defined neutrality as a mobile principle, considering neither concept to prevail from a constitutional perspective. In 2020, in a case concerning Habano school students wearing religious symbols, the court stated in a widely quoted passage that different conceptions of neutrality can be consistent with the Belgian constitution, and that it's not the court's role to give priority to one particular conception of neutrality over others. And you now be wondering, what about Italy? The issue is, of course, debated, but I will give you my opinion. And I agree with the trend towards embracing inclusive neutrality in public employment. I can say that the recognition of inclusive neutrality as a general rule would be its interpretation, would be rooted in the Italian Constitution itself. Although the Italian Constitution makes no explicit reference to the principle of secularism, so laicità, does not prevent and has not prevented the Constitutional Court from extrapolating the concept through an interpretation of the Articles 7, 8, and 19 and 20 of the Constitution itself. In the judgment 203 of 1989, the Court recognizes secularism as a supreme principle of the Italian legal system, stating that, and I quote, it implies not indifference on the part of the state toward religions, but a guarantee by the state of the protection of freedom of religion in a system of religious and cultural pluralism. The pluralism is the key of the, I think, of this rule. More precisely, the neutrality of the state in religious matters should guarantee, on one hand, the complete separation of the state from all religious institutions, and, on the other hand, the full freedom of expression of all religions or beliefs. So in short, the state does not adopt or adhere to any religion, and consequently the meaning of the term neutrality refers not only to the model of relations between the state and the religion groups, but above all to the protection of the religious freedom of all persons and groups. So the recognition of religious freedom requires the state, on the negative side, not to interfere in the religious choices of citizens, but at the same time, on the positive side, to adopt measures that effectively protect the manifestation of this freedom. So, ultimately, this also includes the duty to promote the legitimate exercise of religious freedom. Based on this idea, it could also be said that the state is expected to act in a neutral and tolerant way, Following Dworkin's suggestion, who's an important jurist, American jurist, the state should adopt the profile of a tolerant secular nation. It has permissive towards religion, which is no more committed to atheism than to religion. It should therefore be clear that applying the principle of neutrality does not mean that the state should take on the task of neutralizing religion or secularizing society, let alone promoting agnosticism among its citizens. Rather, it means that the state adopts an attitude of tolerance toward all religious manifestations, and consequently, tolerance is that gives neutrality its content and characterizes it. What must be avoided is that in the name of a misunderstood neutrality, a real policy of secular intolerance is put in place. Neutrality accompanied by constraints, denials and prohibitions would betray itself, since in that case it would be not neutrality, but rather neutralization of religious phenomenon in the public sphere. So not neutrality but neutralization. And here it also be added that the principle of equality under Article 3 of the Italian Constitution provides support to this interpretation. Equality must be correctly understood as the right to diversity and pluralism without privileges or discrimination. Pluralism, as emphasized by Sartori, supports and fosters an open society that reflects a spontaneous order, and certainly respects a multicultural society that exists and has always existed. The primary aim of pluralism is to ensure intercultural peace and not to foment hostility between different cultures. The concept of pluralism and tolerance are intrinsically linked in the sense that pluralism presupposes tolerance, and therefore intolerant pluralism is false pluralism. And if this is true, then we must also agree with part of the Italian literature in taking a critical approach to the existence and limits of the right of religious difference in public employment recognized by the European Court of Justice in drawing boundaries and between the freedom of individuals to express their faith, including through clothing or symbols that manifest it externally. To summarize all the judgments of the Court of Justice, it can be said that the Court has remained neutral between the two concepts of neutrality, with the effect of legitimate both. So, no position between the internal or external neutrality. According to the Court, a public employer may legitimately prevent its employees from wearing religious symbols in the workplaces in two cases. One, if this constitutes an essential and determining requirement for the performance of the job, but this possibility is to be interpreted in a very restrictive sense and exclude that the employer's desire to take account on the particular wishes of the customer. And the second case is if this is established by a policy of neutrality, as in the sentence OP of the Court of Justice, but only if the rule of neutrality is supported by a national constitutional legal basis. This case, the case OP, is particularly interesting and exemplifies very well the terms of the issue. In February 2021, a female Muslim public employee asked to be allowed to wear the hijab, the headscarf at work, but its employer, the local municipality, provisionally denied the request. Then, in March 2021, the municipality introduced a requirement of exclusive neutrality in the workplace, understood as an obligation for each employee, both in their relation with the public and with colleagues or superiors, to refrain from any form of proselytism and to display any conspicuous sign that may reveal their ideological or philosophical affiliation or their political or religious, and of course this is the case, religious beliefs. The Court of Justice examined the case by first recalling certain principles which it considers to be unaffected by the nature, private or public, of the employer. First, it reiterated that the concept of religion must include both the forum internum and the forum externum. It has the fact that of having religious beliefs and the public manifestation of those beliefs. This approach had already been adopted in two cases on the basis of the concept of religious freedom in the Article 9 of the European Convention of Human Rights. Furthermore, the court notes that a prohibition adopted by an employer on wearing any visible sign of personal beliefs may constitute indirect and therefore prohibited discrimination where it applies without distinction to any manifestation of such beliefs and treats all employees of the undertaking in the same way, imposing them in a general and indiscriminate manner a neutrality in dress, which prevents them from wearing such signs. So this is an indirect discrimination, but the court points out that the European law allows indirect discrimination when it is objectively justified by a legitimate aim, and the means used to achieve that aim are appropriate and necessary. And it therefore specifies that prohibitions on wearing religious symbols may be legitimate under these two conditions. In the public sector, the court added that the policy of neutrality must not be justified by a genuine need of the public employer. Because in this decision, the court recognizes that the adoption of a policy of exclusive neutrality may constitute itself a legitimate aim within the meaning of the European law, since each member state and its sub-state bodies must be guaranteed a margin of discretion in the way they conceive the neutrality of the public service. So, in other words, the court considers that the choice to adopt a policy of exclusive neutrality by a public administration taking into account its own context is self-justifying, or at the very least cannot be called into question on the basis of the European law. Interestingly, the court does not claim to have exhausted its review of the legitimacy of the policy of neutrality, and it states that the European legislator has not itself carried out the necessary reconciliation between religious freedom and the aims that might justify a difference in treatment, and that therefore that balancing exercise is a matter for the member states as well as for the national courts. In particular, the member states and the courts, national courts, they will have to verify whether, in the context in which it is adopted, the policy of neutrality is appropriate, necessary, and proportionate in relation to that context, and taking into account the various rights and interests at stake. So, in summary, the court considers that exclusive neutrality can be legitimate under European law, but the court, on the other hand, does not exclude the legitimacy of a public administration choice to adopt another policy of neutrality, such as a general and indiscriminate authorization to wear visible signs of personal beliefs in particular philosophical, of course, and religious beliefs, even in contact with users, or a prohibition on wearing such signs limited to situations involving such contact. Does not exclude, but neither endorse it. So the court does not express a preference of the European legal order for one of the two forms of neutrality, but chooses to abstain. Not surprisingly, this is the decision most criticized aspect, especially in the Italian literature, labor law literature, because a system that claims to be indifferent to differences and to treat all individuals equally, actually treats them unequally, since the formally equal rule produces different effects on different groups. The option for exclusive neutrality, in fact, has the effect of penalizing certain religious groups, which, moreover, represents minorities, growing minorities, but minorities in the European member states. This is particularly true for the subgroup of women who adhere to Muslim religion. And it is no coincidence that all the cases decided so far by the European Court of Justice concerning religious symbols in the workplace has been brought by Muslim women who, as a matter of religious choice, wore the headscarf they joined. Even the court is aware of the particular disadvantage that an apparently neutral rule, such as the one in question, has on persons who adhere to a particular religion or ideology, to the point that said that it is statistically affects almost exclusively female workers who wear a headscarf because of their Muslim faith. And this observes that there is at the origin an indirectly religiously based difference in treatment, which, however, as I mentioned before, does not constitute indirect discrimination if the requirements we have discussed are met. So the issue must therefore be reconsidered to encourage tolerance and respect, that are the keys of pluralism, as well as the acceptance of greater diversity. This will help to avoid distorting the creation of a neutral workplace policy to the treatment of employees who observe religious precepts, requiring them to wear certain clothing. It may also be accepted that for certain jobs, wearing clothing with religious significance is incompatible. For example, because it poses a risk to the health and safety of the workers themselves. It could be possible. However, this hypothesis must always be considered exceptional, as are the justification for the principle of non-discrimination. For this reason, the real demonstrable and proven need underpinning the neutrality policy must be emphasized, as the policy's repressive force on religious identity could bring to indirect discrimination. Otherwise, there is a risk of endorsing a system that marginalizes minorities, forcing them even to choose between freely professing their faith and working. And at the same time, the system would promote a particular conception of good life, favoring religions that does not require the wearing of visible symbols, religions such as the Christian religion, and would promote working environments in which the diversity of social identities is not valued. It is doubtful that the neutral effect of such policies can promote integration in a supposedly pluralistic society, of the improvement of the quality of life, economical and social cohesion, solidarity and free movement of persons as stated by the European legislation. I can also add that from a different critical perspective, the decision to adopt public policies of exclusive neutrality and the European consequent decision to protect and endorse that decision have the effect of preventing workers from expressing their religious identity during working hours, which, as is well known, constitutes a large part of their lives. In the name of exclusive neutrality, public employees are ultimately required not only to be impartial in the performance of their duties, but also to give the appearance of a strict impartiality, which, as far as religion is concerned, is guaranteed by the prohibition of displaying any sign. Inclusive neutrality, on the other hand, requires impartiality at work, in the performance of work, but not the obligation to hide the person's affiliation, religious affiliation. So this opens up a different relationship, which is no longer just one of neutrality, but one of identity. The European Court of Human Rights itself, interpreting Article 9 of the European Convention of Human Rights, which has been taken as the basis for the freedom of religion in the European law, has defined the religious dimension as one of the most vital elements that go to make up the identity of believers and their conception of life. And it is no coincidence that those who have studied the issue of protecting workers' identity in the workplace in Italy have found in an article of the Italian Civil Code, 1942 Civil Code, so a very old law, in an article 2087, the main source that could regulate the limitation of the employer's power to impose a specific dress code on their employees, accepting a conceptual neutral continuity between moral personality and identity. More precisely, as has been argued in the literature, the Article 2087 of the Italian Civil Code constitutes a limitation on employers' prerogative in relation to workers' clothing from the specific point of view of clothing as a protection of their identity traits, and represents a sort of original obstacle to the adoption of exclusive neutrality policies by companies operating in Italy. And this is because the obligation to protect the moral personality of the worker gives rise to both a passive duty on the part of the employer to tolerate religious symbols worn by the employee, and to prevent interference with religious identity, as long as this does not itself compromise, as I said, the protection of the health and safety at work. Such an interpretation of the Article 2087 of the Italian Civil Code is also justified by the nature of the contractual public employment, which is no longer considered, as in France, an organic relation, like an organ is to the human body, leading to a personification of the state in the public employee, but a contractual relationship in which consideration of the worker's debt position is limited to the service required in relation to the professional suitability. This is, moreover, the constraint also prescribed by an important provision of the Workers' Statute, Statuto dei Lavoratori, Article 8, applicable to the contractual public employment, which prohibits the employer from conducting investigation into the religious opinion of the workers or into facts that are not relevant for the workers' professional aptitude or suitability. So this provision classically serves to eliminate any unjustified disparity between the status of citizen, which brings with itself the religious of freedom, and that of an employee, a contractual relationship, and not a status. And this is designed to protect not only the employee's public sphere in strict sense, but also the very identity of the person at work, so including his religious beliefs. And this sums up, and this is the closing idea, so this sums up the fundamental meaning of the provision, that of an intervention to subordinate the need for productive efficiency or impartiality to the subjective and personal values embodied in the factor of labor. The law takes a critical stance, a critical approach toward this ideology, and seeks to prevent that the evolutionary process of a modern society from being exhausted by its internal function of rationalizing progress. it asked by the immediate values of efficiency, proposing instead the imperative of constantly measuring it against a transcendent goal integrated into the totality of human values. So in short, it is possible to bring the organizational power of the employer back within the limits set by the object and the cause of the contract, and to this end, Article 8 defines the values of dignity of the worker that cannot be involved in the employment relationship or can only be involved to the extent strictly necessary and with adequate guarantees in relation to professional suitability or aptitude. So the main idea behind the statute is that the organization must be modeled on the individual and not vice versa. And so I think this sentence can be considered conclusive. I thank you all